Hey, I'm firearms attorney Gilbert Ambler, and I'm back today to talk about what might the Supreme Court hear next when it comes to firearms. And I'm not talking about Vanderstock v. Garland. That one we already know is teed up. I'm talking about some of the other pending petitions that are out there, and I want to talk to you specifically about why they are important and why there might be hope that the Supreme Court will take them. So, before we dive into this subject, if you have not yet hit that subscribe button, what are you waiting for? Hit that subscribe button, like, comment with your thoughts, and share with your friends. That way you and your friends can keep getting this important Second Amendment related content. It has been a big term for firearms at the Supreme Court. We got the Cargill decision, which in my mind, I'll tell you, not a monumental, really not that noteworthy. It told us what I think most of us in the gun world already knew, which is bump stocks are not machine guns. Probably not that wide-ranging beyond that. Same thing with Rahimi. Rahimi, it was an opportunity. We were somewhat nervous that the court might overrule Brune or substantially walk back Brune. They didn't do that. They applied the Brune test in this case. So, and I understand some of you are going to say, well, we don't like how they applied it. Nonetheless, they were clear, and I'll tell you, if you read the dissents, the liberal justices wanted to overrule Brune. Very clear that that is not what they did. What's the biggest case of the term? Probably the Loper case, Loper-Bright case. I mean, this is not a specific firearms case, but this struck down Chevron deference, and that is a huge blow to a lot of the plans of the ATF and the administrative state that want to use their regulatory powers and their regulatory interpretations in a way that come after honest, law-abiding folks, because they required the courts to defer to what the legislator through the ATF or other regulatory agencies wanted to do. That's no longer going to happen. Now courts get their own independent read. If you don't understand the significance of this, it is huge, because this Chevron deference is what allowed agencies to prevail. Because when an agency like the ATF would interpret a statute in a way that a statute could be read either way, ATF would offer their interpretation. Courts under Chevron were required to adopt the agency's interpretation, even if the court would have read it differently. The court is no longer confined to adopt the agency's interpretation. Now the court has to render their own independent interpretation of the statute. And that's huge when you've got agencies like the ATF that don't like firearms but are governing firearms, so they're looking for any way possible to restrict firearms. All right. What we're talking about today, however, is the pending petitions. And there's two types of cases that are pending before the Supreme Court that I think are really important. The first is sensitive locations, and that's the Antonyuk case. The Antonyuk case out of New York, a Brune response bill, involves a whole variety of locations that the government deemed as sensitive, basically ignoring what Justice Thomas said in Brune, where he said, you can't simply call crowded places like Manhattan sensitive simply because there's a lot of people there and have a general police presence. Well, that's almost exactly what New York did in the aftermath of Brune, and it's very important because we see governments across the country taking this stance, trying to sort of wave a magic wand and calling all sorts of locations sensitive. Antonyuk's interesting, very, very important case, and one that would be good for the justices to hear. The other one that I think is even more interesting to me is all of the cases involving what they call assault weapons. There's 5 separate petitions from the state of Illinois involving Illinois' assault weapons ban. Now, Illinois assault weapons ban, for those of you that don't know, very, very overarching ban. I mean, not only did they go after, they sort of did a combo, a hybrid type ban. You often have states where they're banning features, which Illinois did. They did, anything that is semi-automatic rifle accepts a detachable magazine plus one feature, such as a collapsible stock or a thumb hole grip. So that was one type of weapon ban. The other type was a weapons ban by name. So they said AR-15s, AK-47s, etc., and went down a list of weapons that they banned. And then finally, for good measure, they threw in rifle magazines capable of holding over 10 rounds, pistol magazines capable of holding over 15 rounds, and a whole assortment of other things like some semi-automatic shotguns and some specific handguns that they went after. So hugely limiting the type of weapons. And in upholding this law, I just want to remind people, I know there were a lot of gun YouTubers talking about this case when it first started, but we need to talk about why it's important before the Supreme Court. And that means I want to refresh your memory. Initially, gun owners of America got an injunction against this assault weapons ball. That injunction was overturned by the Seventh Circuit. Okay, and when the Seventh Circuit overturned it, what they did was they created what I would call a made-up test. And essentially what they said was they disconnected the militia portion of the Second Amendment. Now, remember, back in 2008, Justice Scalia, with the Heller decision, gave us a very thorough write-up on how the Second Amendment is to be interpreted. The Second Amendment, which says a well-regulated militia necessary to the security of a free state, the right of the people to keep and bear arms, shall not be infringed. All right? Now, we want to go to that first portion, because prior to 2008, there were lots of folks out there that were claiming you had to be in a militia, that the right was only granted to a militia. When Scalia broke this down, Scalia said that's not the case. That militia portion at the first part, that's a preparatory clause that announces a purpose, but it is not the same as who the right is granted to. The right is granted, it's an individual right granted to the people. The purpose is because a well-regulated militia is important to the security of a free state. Illinois says what Heller did was completely get rid of the militia portion. Illinois says when Heller severed that militia portion from the right to the people, it meant that the militia portion was essentially meaningless to them. And what they say after that is that they're going to draw a line between military weapons and civilian weapons. And this is a judge-made line, and judges get to look at a weapon, determine whether it is military in character or civilian in nature. What is civilian in nature? Well, the court says it's weapons that are useful for self-defense, since that is the core of the right. Now, keep in mind, many weapons that are useful for self-defense, like AR-15s, for example, are also potentially useful in military service. They can have more than one use. However, the court says it is constitutional to restrict arms that are useful for military service under the Constitution. In fact, the Seventh Circuit claims if a weapon is useful to the military, it doesn't even count as an arm under the Second Amendment, and they don't even have to apply the Brune test. They can simply say, not an arm under the Second Amendment, not covered by the text. You don't get any text, history, and tradition test. That's what the Seventh Circuit says. Seventh Circuit, literally says AR-15s are not arms because they're too useful to the military. And I guess by this reading, really the only things I can imagine that might be actually protected if the Seventh Circuit reasoning prevails are things like, maybe like pocket guns, J-frame revolvers, derringers, things that would only really be useful for self-defense. And I can't have a hard time imagining their use in a militia service. Because keep in mind, the militia brings weapons that they have already available at home and enter them in militia service when called forth to defend their state or their country. So the type of weapon, and when we talk about an AR-15, yes, that would absolutely be useful in militia service because it's the type of weapon people have at home, very commonly owned weapon. You'd bring it forth when called forth to serve in a militia. So in my opinion, Seventh Circuit got this all wrong. What's going on with this case at the Supreme Court? Well, as I said, there's 5 petitions, and these petitions are circulating. They keep getting circulated at conferences. Now, it's possible that they're getting circulated simply because, and this is definitely a possibility, that they're waiting on dissent from somebody. That they've already decided not to take the case. Justice Thomas is writing a dissenting opinion, and we're just waiting for Justice Thomas to get his dissent in. That's possible. And depends how much of a conspiracy theorist you are, I somewhat wonder whether the conservative justices want to take this case, want to smack Illinois for ignoring Brune, and don't want to take this case with an election year pending. Because they know what the media will do, and if you don't think that the media affects how these justices vote, look at how Justice Alito has been voting compared to how he has voted other years. Justice Alito, not the same Justice Alito that we've seen in past years, and of course, Justice Alito taking a lot of heat in the press. So if you don't think that the justices are worried about the press and they don't think they're worried about what happens in an election year, I think they're human. I think it's natural for them to be worried about that. So this is my conspiracy theorist-minded take. This is my hope. Perhaps the justices are going to take one of these cases, are going to smack Illinois down, but they're going to wait until after the election to take these cases and just sort of keep them sitting and circulating until then. We don't know what's going to happen yet. You'll have to stay tuned with me to find out. If they do take one of these cases, you can bet we'll keep you informed. Until next time.